Welcome everyone. I'm Russell Alexander. I've been a lawyer with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We help families with separation and divorce. Without further ado, let's get into today's topic. Was the trial judge right in Ballparking to reduce the wife's equalization payment by 90%? The Ontario Court of Appeal recently considered whether a trial judge was required to use a mathematical formula when arriving at a proper figure for unequal division of the former couple's net family property. In that decision, the separated spouses had lived together for 4 months prior to their 4-year marriage. They had no children. The wife was currently 46 years old, self-sufficient, while the husband was 69 years old, retired, and in receipt of CPP and OAS payments. They went to court to resolve the sole remaining issue between them, which was how to equalize their net family property, or NFP. Under the Family Law Act, the court was allowed to vary what would otherwise be the spouse's NFP if it was of the opinion that equalizing the NFPs would be unconscionable. The Family Law Act also specifies that one of the factors to be considered in this assessment is whether the period of the spouse's cohabitation period is less than 5 years. At the previous hearing, the trial judge declined to order a strict equalization for a number of reasons. Number one, the wife's NFP was largely derived from gifts given to her by the husband. Number two, in light of the relatively short period of cohabitation, a full equalization payment would be disproportionate. And number three, the spouse's respective financial contributions to the property that they owned during their marriage was skewed. For example, the wife made no monetary contribution at all to the purchase of their matrimonial home. As a result, and instead of giving the wife a full equalization amounting to $106,000, she was ordered that the wife would receive only 10% of that, or $10,600. This, however, was in addition to the $200,000 that the wife had already received from the sale of the matrimonial home. If you're enjoying this video and find it helpful, you can give us a thumbs up, or please leave a comment in the box below. The wife appealed, arguing that the trial judge had erred in finding that 1, a full equalization would be unconscionable, and 2, that 10% of what would otherwise be the full equalization payment would be just and equitable. The wife also complained that the trial judge's reasons lacked sufficient detail on how she arrived at the 10% figure. With all this in mind, the wife asked instead for an unequal division of 87%, which aligned more closely with the 5-year marriage factored specifically adverted to in the Family Law Act. Their whole cohabitation period was 52 months out of the possible 60. The Court of Appeal rejected the wife's argument and her appeal. First, it confirmed the trial judge had correctly identified the governing law, including considering the appropriate factors in the case precedent that allowed for varying the equalization share in light of the circumstances. Secondly, the trial judge found that the wife had benefited financially from the comparatively short marriage. She received $200,000 from the sale of the home, despite having contributed nothing financially to its purchase. She did, however, contribute $16,000 to the cost of renovating, but this money had come from the sale of her condo, which was entirely financed by the husband before they married. She used the remaining $33,000 of those condo sale proceeds to pay off her own personal debts. The wife would also benefit from the engagement ring she got from the husband and the wedding gifts, which totaled $87,000. Finally, the trial judge noted that the difference between the spouses' respective NFPs at separation was due almost entirely to the growth in the husband's investments over the course of the 4-year marriage, which was another thing the wife had not contributed to. All this correctly led the trial judge to find that a full equalization of the NFPs was unconscionable. The Court of Appeal found the threshold for the unconscionability under the Family Law Act is high. It is more than mere unfairness. The court added that the high bar for unconscionability precludes trial judges from undertaking minute parsing of the parties' relative contributions to the marriage. It also promotes the goal of certainty in family law disputes. Although the Family Law Act's reference to marriages of less than 5 years was relevant to whether full equalization might be unconscionable, in this case, the trial judge applied the pertinent criteria to the facts and had come to a reasonable conclusion. As the Court of Appeal noted, the court does not agree that trial judge made an error in the exercise of her discretion. Although applying a mathematical formula based on the length of the marriage provides the benefit of certainty, neither the Act nor the relevant case law requires the judge to do so. The trial judge's decision to award the wife 10% of a full equalization was a reasonable one that flowed from the facts presented to her. The appeal court dismissed the wife's appeal. For the full text of these decisions, look below. You can learn more about the case and the full article in our description below. We've provided it for you. Please leave your thoughts and questions in the comment box below. Once again, if you liked this video or found it helpful, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.